ye, hear ye, hear ye. All persons having anything to do before the Honorable Beverly Canone, Justice of the Superior Court, holding in Dedham within and for the County of Norfolk. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is in session. Please be seated.
Good morning.
Good morning. Happy Taco Tuesday.
Tuesday, June 10th of 2025.
It's day 30
of the circus. That is the re-persecution of Karen Reed.
Karen Reed's second trial. And
we're getting ready to see what fresh hell awaits us today.
So again, we're in morning housekeeping. The jury is not there. The defense filed a motion this morning.
And that is some of the issues with Dr. Laposata.
To talk about bite wounds. So I've read that.
Correct. I'd like to be heard on that briefly.
Okay, sure.
Thank you.
Hell yeah, AJ.
I thought we would see the defense argue more about Dr. Laposata being able to get into the dog bites.
He was using Dr. Laposata to question whether or not Dr. Russell had any kind of methodology.
There is not and should never be an obligation, but he's saying the Commonwealth has basically put us in a situation where we do have an obligation.
And he uses multiple catchphrases that we have said on this channel and have heard throughout this trial, such as grave concern, using something as a sword and shield, and of course, the prosecution potentially burden shifting.
And now we are getting into, did the Commonwealth open the door? Not, Your Honor, reconsider that this expert is an experty expert. No, go about it a different way.
Now they exclude her and he can't fight it.
The jury is going to think, listen, there's a report from this witness about dog bites and dog bite analysis. And then this witness never tells you what that report says. It must be bad for the defense.
I'm not surprised that they are finding a different way, saying, hey, the Commonwealth opened the door. Let's see what AJ has to argue.
We had some concerns yesterday and previous to yesterday about an issue that has been ongoing with the Commonwealth, and we've brought this to the court's attention. The Commonwealth has been using a tactic to shift the burden to the defense with cross-examination that's laced with indications or implications about witnesses that may or may not be called by the defense. That is a problem. I brought it to the court's attention at sidebar. The court will probably remember that colloquy. It was not an open court, but I expressed grave concerns, to use that phrase, that there was a burden-shifting system that was going on when Mr. Brennan is asked.
Jackson, spending too much time on the internet. There were the defense has grave concerns.
So the great line is him saying, I have grave concerns, because that is exactly what Judge Canone said. And yeah, it's a whole thing.
Grave concerns about the burden. He's so happy with himself about the burden shifting questioning of the Commonwealth.
Asking our witnesses about, or his witnesses, about other witnesses that may be on the defense witness list and may be called. Obviously, as the court knows,
I have grave
foundationally,
concerns about more
we don't
than
have to
this.
call anybody. But we shouldn't be put in a position where our hand is forced to call witnesses because of questioning by the Commonwealth, which is improper. We pulled the tape. Dr. Russell was cross-examined by Mr. Brennan on the issue specifically of Dr. Laposata and her opinions regarding dog bites.
Dr. Russell was asked by Hank Brennan on the stand about Dr. Laposata. Do you recognize Dr. Laposata? Do you know about her report as it relates to dog bites, as it relates to pattern recognition analysis?
Dr. Russell said, yes, she was familiar with Dr. Laposata by name, that she thought she had impeccable credentials.
And we remember this, right? Russell was like, oh, I'd love to hear her opinion. What did she say?
And she very much wished she could have seen her reports as it relates to dog bites.
Brennan brought it up and definitely was trying to get the jury to infer that they disagreed, that it was not the same.
It was an intellectual curiosity by Dr. Russell that was evoked and elicited by Mr. Brennan on cross-examination of Dr. Russell.
And now, if you're not going to allow us, the defense, to ask Dr. Laposata about her pattern recognition analysis, it looks It looks like the defense is hiding this information because it's damaging to them.
This was actually good.
But Jackson makes a great point here. Brennan's the one that opened this door to Laposata discussing dog bites.
And Alan Jackson's like, we should be allowed to do it because it was opened the door, the Dr. Russell testimony, and she opined on it. And so we should be able to talk about it.
And in fact, he kind of is trying to make the jury think something that we don't think is true. And now he's trying to block us from getting the truth out there and letting her talk about whether or not she thinks these are dog bites.
These are good points. He opened the
She was
door.
then asked the seminal question. Did the defense, Dr. Russell, give you any reports by Dr. Laposata related to dog bites?
What page is that on here?
And the transcript? No.
Come on, Jackson, have it ready.
My motion's back.
Or Miss
Yeah.
Little,
Miss
have
Little.
it ready.
He needs
My motion's
Elizabeth
back.
Little to hand it to him.
Miss Little's got this. Told you.
Miss Little is a star.
He's a stand up and argue type of a lawyer, not a where are my papers type of a lawyer.
Okay. I'll just
Read from the transcript.
I'll just read it. Question by Mr. Brennan. Have you ever heard of a doctor named Laposata?
So are you going to read all 3 pages?
No.
So I've read it, Mr. Jackson.
I'd like to read it into the record, Your Honor.
Yes.
It's in the record. I will put this transcript into the record.
I'm sorry. Didn't she just say what page? Let me hear it. And now she doesn't want the world to hear it. You see, he needs to read it into the record to preserve the many appellate rights that Karen Reed has, the many issues. Push her, Jackson, push her.
The Commonwealth then moves to exclude the very testimony that he was eliciting from Dr. Russell, leaving the jurors with a very, very deep and irremediable misimpression.
He's like, thank you, Mr. Alessi. Irremediable is our new favorite word.
They used it tactically as a sword and a shield. And that's burden shifting. That leaves the jury with the impression that Dr. Laposata was consulted by the defense, number 1, that she wrote a report, number 2, that the report was about dog bites, number 3, that she didn't provide that report to other experts, number 4, and the reason she didn't, obviously, is because her opinion, Dr. Laposata's opinion, would be harmful to the defense. That's the only reasonable interpretation of those facts.
And that's been the MO of the whole trial. That's exactly what he's trying to do, what lawyers are allowed to do. And say, oh, they didn't give you this or they gave you that, or we're going to knock your credibility, or you don't have all the information. That's totally fair game. But when you do it and it's just wrong, and then you try to block the correct truth from coming out, that's where it becomes problematic.
They never gave up on this. They wanted they lost this already, and this is a reconsideration to get Laposata to be able to talk about the dog bites.
Dr. Laposata's opinion has never wavered. Those injuries on John O'Keefe's arm are from a dog. Period, full stop. Anything less than presenting that to the jury at this point would be to perpetrate an intentional fraud on this jury. Ms. Reed is entitled to more. She's entitled to better. She's entitled to the evidence.
All right, thank you. Mr. Brennan.
All right. Thank you. Thank you, Mr. Jackson. Good night.
Perpetrating an intentional fraud on this jury if you don't allow it. It's a powerful argument.
We cannot leave the jury with another wrong impression created by the Commonwealth.
I know you said we couldn't, but Brennan makes us. So that's the crux of this argument, and it's a good argument.
Mr. Brennan.
Shut up, Brennan.
Oh, God. I have to hear him talk now. Go ahead, lie to us.
The pattern of conduct that stands out is persistent, repetitive, contrary to court rulings and court orders, and deliberate. The defense uses their witnesses to vouch for their own credibility. They use their witnesses.
You ask their witness about credibility, you absolute pillock.
They use their witnesses to introduce information they know is not admissible, and they use their witnesses to introduce otherwise inadmissible hearsay.
Pot, meet kettle.
You did this. You're the one who brought this in. So
What do you mean she was vouching for her own credibility? She gave you her credentials. Why is that even a sentence?
He's not using her to vouch for anything. You opened the door by asking if another witness could vouch for her credibility.
You have done nothing, if not deliberately lie to the court. Wow, he's got some cojones this morning, eh?
Dr. Russell took the stand. She denied ever reading anything about Dr. Laposata. I did not specify whether she read an opinion about a dog bite. I asked if she had heard about Dr. Laposata.
We just heard it.
She denied it.
We
and then
just
she told
heard
us that
it.
She knew about Dr. Sheridan. Unsolicited then added that Dr. Sheridan.
Unsolicited, but the question was, have you heard anything from anyone else about those opinions?
I don't know how she became aware of Dr. Sheridan's testimony, and since the defense doesn't speak to her about these things, she must have watched it on her own. But inevitably, she introduced inadmissible hearsay.
Okay, now you're accusing Dr. Russell of violating the sequestration order, watching testimony on her own, or maybe watching it from last year, which may not violate the sequestration order. Just like you insult, do you have memory problems? And the gasp heard around the world came out of her mouth. How dare you impugn this woman's integrity? How dare you?
She did not provide a basis, and so her opinions regarding dog bites should not be permitted in this trial.
Clear up the record. Two things stand out about that speech.
That speech.
Mr. Brennan literally just said,
They are a little snarky
I
at
didn't
each other.
elicit any information about dog bites.
Yeah.
I just asked about her experience.
Let's do it again.
Question by Mr. Brennan.
That is what you said. Fuck off.
Oh boy. Oh boy. Somebody texted me and was like, this is like the ASAP Rocky trial now.
He is not fucking around. He is done.
God, they're so pissed at each other. They are so done with each other.
He's like, Brennan literally said this. He's like, I did not say that. Jackson's like, excuse me. He's like, I will not excuse you.
When are they allowed to do this? Since when are they allowed to be like, that's not what I said. That's not what I said. Since when are they allowed to do that?
Guys know that in the courtroom, the attorneys do not talk to each other. The attorneys only talk to the judge. The judge talks to the attorneys.
Usually they've been professional. They sit down, they let each side make their arguments, even if they're taking personal shots at each other. Brennan wasn't going to stand for this. And the judge is like, children, relax.
There's a rule of professional conduct.
And again, he does this because he's in a lawless courtroom and he knows the judge ain't going to do shit about it. You can do whatever you want.
That is unethical. And yet we see it repeatedly. Nothing, no issue. He can get up there and argue, lie, dispute.
You know, he can stand up and object, but he can't, like, he's not supposed to get into an argument, like a slap fight with Jackson.
But this is how you know it's getting under Brennan's skin at this point.
Brennan's caught with his pants down here.
Yeah, I didn't know you could just interrupt and be like, that's not what I said. Like, this is Congress or some shit like that. Like, you just yell shit out. What?
It's embarrassing. It's like a Maury Povich show in this courtroom.
He's not supposed to address counsel directly.
You don't need to tell me what Mr. Brennan said, but go ahead to your
How about
argument.
if I quote his words? How about that?
How about that?
Question.
Shit.
And so you.
I said, I didn't say dog bites. Yeah, you did. Yeah, you did.
Don't clap back at the judge when you're mad at Brennan, though. How about I quote his words?
Yeah, I do need to tell you what he said, Judge.
We are being gaslit to think that he did not say any of these things. And that is exactly why Alan Jackson wanted to read that into the record.
If he's wrong or if I have a transcript, I'm going to tell you his words. Like, what do you mean? Yes, that's not the appropriate response by a judge. A judge is, you two don't talk to each other. You talk to me and Mr. Brennan, sit down. It's Mr. Jackson's turn. When Mr. Jackson's done, you can stand up and have your turn. This is a profession of ethics. We're supposed to be professional. Let's act it.
Run it back.
You think of all those forensic pathologists, medical examiners, and you think qualification and experience itself is not enough to qualify somebody to give an opinion on a photograph about the genesis of a wound related to dog bites. The question was specific to dog bites. That's how he introduced the subject matter to Dr. Russell. Then his next question was, have you ever heard of a doctor named Dr. Laposata. Those were his words. Then turned around and 3 days later said, and by the way, the defense should be disallowed from using Dr. Laposata to talk about the very dog bite wounds that I asked Dr. Russell. That cannot stand in the school.
That was a powerful argument by AJ.
You don't get to get up again, Hank.
Go ahead.
It's helpful if you view the entire thing in context. Like, well, we always have a right to object in a small opinion.
There's no rule of law in this
All right.
courtroom.
Shut up, Hank.
All right. I'll be out in 10 minutes on this, and we'll get started right away with Dr. Laposata.
Yeah, she's got to go make some calls.
Judge retreats to make a phone call, phone a friend.
She got to go make some calls. She takes time out for this one.
She gonna go check with somebody? I gotta go consult somebody here.
No, of course she's running out to think about how are we going to hold Hank accountable for his appalling courtroom behavior.
I don't know how the judge can with any degree of professionalism side with the prosecution at this point. I think they've opened the door. How far they've opened the door? Probably all the way.
These people done got my blood pressure up early on a Taco Tuesday.
Thank you, Mr. Jackson. It's denied.
All right.
Denied.
So I'm not going to allow Dr. Laposata to testify regarding dog bites. Your rights are saved.
Objection.
So she says, denied.
Objection.
The fix is in.
Your rights are saved.
Shock.
I'm going to give an instruction
Objection.
The fix is in.
regarding burden shifting.
It's a pretty heavy-handed instruction, by the way.
Oh, big deal. Like the jury's going to understand what that means. Like, that's not going to help.
What is an instruction about burden shifting going to do? It's going to do nothing. It's not going to help.
But right now, Jackson's going to stand up and he is going to fight for his client, and he's 100% right.
It's something that should be done when you know the judge is not going to rule in your favor. And it's something that I don't think the defense does often enough.
You keep pushing if you're a lawyer.
That this is what you have to do. You have to come up with something.
You try to find different ways to make it work. You negotiate.
That gets you at least a modicum of what you want. You got to know your judge.
He asked for everything. Once she says no,
you got to know what's going to be the splitting the baby, where's going to be the even road, and ask for it.
Now he's going to ask for something simpler.
Wow.
I think it's outrageous.
He starts saying outrageous, but I can't hear what he says is outrageous. It's definitely not Jim.
He said, I think it's outrageous. And I think he's saying Brennan's conduct is outrageous.
Instruction can do anything except bring the point home.
Okay.
But
Okay.
if the court is not willing to allow her to testify to her full opinion to a reasonably great science of concerns, can she at least split the baby?
I will do that.
All right.
I'll allow that. Yes.
I was shocked after she came and just said a hard no. He's like, can we at least split the baby and say consistent with animal injury or whatever he said? And she's like, I'll do that.
Auntie Bev said, no, you can't talk about dogs, but you can talk about animals bites.
Big win that she can say it's consistent with an animal.
It's like, bro, you realize that's a win, right? Like Auntie Bev, like when we talk about like animal bites, everyone's going to know we're talking about a dog, right? As long it has 4 legs and a tail, whatever the fuck bit it. And whatever it is, it's not a tail light. So that's good. It's good.
It's like, that's it. Sometimes you just have to ask again.
And that's what Alan Jackson just did.
Sometimes you just have to push. Sometimes saying it's outrageous.
And although I think her ruling is bullshit,
she already made her bad decision, in my opinion, to not allow it in.
At least they just got something.
That was eye-opening to me and surprising to me, but I'm so glad she did it because I think it's appropriate. Great job by Jackson not giving up. You have to have a lot of cojones to stand up and continue to fight even after you've lost.
So now let's hear what Hank is going to whine about now.
Oh boy, she's panting.
Consistent opinion with the dog.
No, Mr. Jackson said animal.
I'll leave it at animal if that's what I can get. I'll take what I can get.
In her experience, Mr. Jackson, you have to lay a foundation. In her experience,
She has the
saying
foundation.
animal.
The foundation has been well fucking laid. Are you joking?
This woman is so qualified, it's ridiculous. She has actually taught classes on this. And the fact that she's like, well, I mean, 50 cases where you've seen dog bites. No.
Y'all, she teaches medical school classes on this, and she's not allowed to testify about it.
I'll come to sidebar before I display anything. That will include a representation of what an animal jaw looks like.
No. No, it will not.
Why is that?
That's my ruling, Mr. Jackson.
That's what I said so.
No visuals, just that one sentence. So there are two other quick matters, but the jury's been here, and I don't think we'll get past.
Well, Cundy McCuntface, sorry, I'll demonetize all of us. You were 17 minutes late.
It sounds like she's not giving an instruction on burden shifting. Emily, what the fuck just happened? I don't even know.
You get the one line. Why? Because I said so. Because I said so. Like we're a bunch of toddlers in here and she's just mommy.
We're watching on full display in front of a worldwide audience what we who were here for pre-production of season 1 and season 1 have been shouting about and enduring and watching painfully.
While we were talking about the king, this old idea, the king's authority flows straight from God, so he can do no wrong.
She's like the kind of judge that you see on those movies when you're like, thank God that's not real life. But it's real life.
Real similar kind of attitude we see here in this court because I said so. Nobody gives a shit what you think, Judge.
A woman who could be you, could be me, could be your sister, my sister, your daughter, your girlfriend, your wife, be railroaded.
It almost looks like it's set up so that peons like you and me can be accused of crimes and railroaded, and we have no recourse. Can't do anything about it.
And forced to defend herself in front of a kangaroo court, Kim Jong Canone presiding.
So imperial, the imperial court that we witness here in Massachusetts, powerless against the government, almost looks like that's on purpose.
Wild. The problem is judges have a lot of discretion and a lot of power.
And if this can happen to Karen Reed, this can happen to any one of you, and you should be mad as hell.
I want it to be fair. I want it to be fair for the defense and fair for the prosecution and fair for the victims. And I don't see it right now in this trial. I don't see it being fair. It's one, the sun shines on one party and not on the other. And the judge is the clouds. So, there you go.